Well, it's a pleasure to be here. What I'm going to do in my short opening remarks is talk a little bit about the theme of the panel, about the government's initial response to the financial crisis, and then I'll touch on three current issues that are live, and they include executive compensation, resolution authority, and investment management by the government. Okay, so the panel is about the blurred line between the public sector and the private sector, and I think my theme in this talk will be, should we worry so much about the blurring of that line? I've often wondered whether bureaucrats who work for the government are so different from bureaucrats who work for IBM. And I've often wondered whether the networkers on Capitol Hill are so different from the networkers on Wall Street. Some are looking to sell a bill, and others are looking to sell a company. And, you know, I've also wondered if it's true what they say, that Washington is Hollywood for ugly people. So if those things are the case, you know, what is it organizationally that would make us worry about setting up a public sector that looked like a private sector, and also on occasion involving the public sector and private sector type activities? Indeed, I sort of welcome an organization of the public sector anyway along more private sector lines. Okay, so the government's response to the financial crisis was, to be sure, a stretch of certain Depression-era statutes, as David has noted, creative interpretation at times of the Emergency Economic Stabilization Act and the TARP, and a use of deal-making and agencies like the Fed and the Treasury Department that don't ordinarily follow the usual prescriptions of the Administrative Procedure Act and judicial review to get around those rules of administrative procedure. So that sounds alarming, but let's face it, the initial response to the financial crisis appears to be working. A collapse of the credit markets was forestalled, at least for now. You know, although the government, through the Fed and the Treasury Department, deployed a dizzying array of tools, some of which worked and some of which didn't, and some of which were particularly creative interpretations of statutory authority, if you're going to give people flexibility on how they implement their missions and then hold them accountable for their results, which is a management technique we teach quite early at the Wharton School, and one adopted by the last presidential administration, then I'm not so sure we should worry so much about the basics of that financial response, and instead judge it based on its results. So what about today? What about once we've made it to a bailout, the fallout and the blurring of the public-private distinction that currently exists? So what I'm going to do is, I think I have more equanimity about some of these issues than most of the people, but I'm going to raise three of those issues and say why you might want to worry about them, and then describe why I'm less worried than you may be. So what about executive compensation? Well, basically, executive compensation, as it's being implemented by Kenneth Feinberg, is you know, the public regulation of private ordering, indeed some of the most fundamental aspects of private ordering, contracts of employment between private actors. So that sounds pretty bad. What Kenneth Feinberg did for the companies he has been overseeing is he's reduced pay packages and tried to make them so that they vest in a long-term way. So that's pretty dramatic, but let's face it, what the Feinberg Mandate and remit was to adjust the compensation of all of 7 companies that had achieved extraordinary relief, being given extraordinary amounts of relief under the TARP. Feinberg has said, and the Treasury Department has said, that they hope it'll be a model for the future. And the Federal Reserve has told financial institutions that it will be issuing guidance which, along the lines of the PAYSAR, or so-called PAYSAR's recommendations and requirements of the 7 companies receiving extraordinary assistance, will be focused on making pay long deferred and trying to do more to align the interests of corporate executives with shareholders. But all I'd say about this dramatic imposition is, first of all, of the public sector and the private sector, is first of all that it's worth noting that it's only been applied to a few firms so far, 7 in the case of the PAYSAR, not all the firms receiving TARP money. And as for the Federal Reserve, they've issued only guidance, but no hard rules about executive compensation. Secondly, you might ask if you wouldn't reduce the compensation paid to executives if you were, say, a private equity firm that owned 7 companies that had failed during a recession or all but failed. You might try to hold those executives accountable, and it's not clear to me that that isn't part of what the Feinberg pay compensation rules are doing. Okay, so what about resolution authority? Well, this is really striking power that is claimed by the government. And in the Dodd Bill, it's a striking power that would be broadened to cover not just banks and thrifts, but all sorts of financial institutions. It's a striking power because it allows the government to come in and seize, that is, nationalize a private company. And there's no pre-deprivation process, and there's very little post-deprivation compensation. So once again, the question is, should you worry? And should you worry, especially if the bargain that the government has extracted for resolution authority, that is the granting of a valuable thrift or bank charter in exchange for the ability to take that charter away, essentially, at any moment, whether that bargain is sort of being changed if resolution authority is expanded not to deal with just banks and thrifts, but with a variety of financial companies that don't make money on the basis of their valuable bank or thrift charters, like insurance companies like AIG, or other financial institutions. The Treasury Department has suggested if it gets the resolution authority it wants, it's possible that some hedge funds or private equity funds involved in involved in the ownership of financial institutions could be subject to the resolution authority discipline. So I think this is very dramatic government intervention. And I think that if resolution authority is passed in an extended way, it ought to be accompanied with a published list of companies covered by the potential for resolution authority at the beginning. And perhaps at the end, there ought to be an auction process once a company is seized, whereby its owners could try to buy it back before it is dispatched. But it's worth noting that resolution authority is, though dramatic government intervention, hardly unprecedented government intervention. The FDIC has been resolving failed institutions for years, and so state banking regulators. And also, it's worth noting that resolution authority is not going to become the only thing that the government does when it gets involved in the financial regulatory system. The government had strong resolution authority powers over Fannie and Freddie, and it hasn't yet deployed them, and my suspicion is it will not. So it's also worth noting that constitutionally this power is being upheld time and again, and that may be because it is, as I've said, a power of long-standing existence, one that existed before the procedural revolution and Goldberg versus Kelly, and one that I think may continue to exist in the future, but I would agree that resolution authority is something worth taking a close look at. Okay, so the final thing I wanted to talk about a little bit was investment management by government supervisors. And I think Jay Verret will talk about this in more detail, and so I'll leave it to him to handle most of the issues. But it's possible that the government will retain a stake in the companies it's involved itself with longer than absolutely necessary to maximize the net asset value of the corporation or to ensure its safety and soundness. The idea here is that the Federal Reserve Board or the Treasury Department may forbid a bank from paying back its TARP funds until it hits a capital adequacy level well above, say, 9%. Or it may be the case that the government stays in companies like AIG and Chrysler for years until their insurance and car businesses come back, if they ever do. That's a lot of government ownership and more than absolutely necessary. But again, I ask you to think about whether you would want a private sector company to sell before it had maximized the net asset value on its investment. It's also worth noting that capital adequacy has also been around for a very long time, at least since the 1970s and probably informally before then. Okay, so finally, I guess I'd say that it's worth noting that people go to jail after financial crises. In the savings and loan crisis, the Federal Home Loan Bank Board, which is today's Office of Thrift Supervision, referred 11,000 cases to the Department of Justice for prosecution, and that was in 2 years. In 1992, there'd been 1,000 convictions of S&L executives and a reported conviction rate of 91%. And the GAO concluded that of the largest 26 thrift failures, 60% of them had been marred by serious criminal activity. So one of the things that's most interesting about the private sector's response to the public sector and the financial crisis is that there doesn't appear to be a real worry about the political risk inherent in retaining some of the practices that existed before the financial meltdown. You may say to yourself, well, thrifts are Main Street, and Wall Street's more politically juiced. But there's been no convictions so far, no successful ones, almost none, of financial executives in the aftermath of this crisis. And there are 3 grand juries investigating now. I suspect there will be more to come. To me, it's interesting to note that companies like Goldman Sachs are still compensating their executives and employees at the high rates they were compensating them before the crisis. And it suggests to me that, that the appetite for risk, including political risk and the risk of criminal prosecution, still exists in some of these large financial companies. Thanks.